Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to have fun here on YouTube making the law make sense to the extent that it can. And today we have to ask the question, is it really true that a lawyer who has himself for a client has a fool for a client? I'll let you make a decision about that. More on that in just a second. So everybody knows about Michael Avenatti, the lawyer who represented Stormy Daniels, who basically tried to get a number of people to make statements against Judge Kavanaugh. Probably not somebody that conservatives have a great deal of love for, and to the extent that he has fallen out of favor with CNN and some of the other cable news networks, perhaps not even many liberals give Mr. Avenatti the time of day now. Well, the problem for Mr. Avenatti, the thing that got him into trouble, was that he was always looking for the next dollar. And sometimes when you are hustling to make that dollar, you take shortcuts and you cut corners and you do things that realistically you know you shouldn't do. And that's what got him indicted in the Nike case. He got sentenced to 30 months, I believe, there. He's a convicted felon on basically on extortion charges. So it would be difficult to libel Mr. Avenatti, but I will try not to, and we'll stick to the facts to the extent that we can here. So in addition to being on trial for that earlier this year, he's now on trial in Los Angeles, or I should say Orange County, for essentially taking money, converting money or embezzling money from his clients. Now, what happens when a lawyer makes a settlement for a client is that the money comes into the lawyer's trust account. The lawyer is supposed to hold that money in trust for the client. He does that for a couple of reasons. One, sometimes checks bounce. So he holds that check to make sure that it's going to clear. When it does clear and the money's there, he has an obligation to immediately do two things. He can reimburse his expenses, those expenses that he incurred out of pocket in bringing the case, doctor bills that he's paid, medical expert reports that he's obtained, depositions that he's taken, court reporter fees, those sorts of things. He can pay those, and those reduce the amount of money available to the client. He can take whatever contingent fee that he has coming out of that account. The rest has to be immediately paid to the client unless the fee agreement specified something else. And in the case of at least one of these gentlemen, it did not. Mr. Avenatti had a client by the name of Johnson who was admitted to the jail in Los Angeles County because he was having a mental health episode, and even though his family told the sheriffs there, hey, the guy's suicidal, they didn't watch him closely enough or they didn't restrain him, whatever it was. He jumped out of a window and he became a paraplegic. So they hired Mr. Avenatti to represent him, and Mr. Avenatti very quickly got a $4 million settlement from the county of Los Angeles. Now I want to make something clear. A lot of people think that the ability to get a settlement like that is a mark of a really great lawyer. It's probably not. What it is a mark of an attorney who is very good at intimidating defendants. That's basically what a lot of these lawsuits come down to. Do you really want to go through trial where you're going to have to pay your lawyers thousands of dollars to try and defend this case and perhaps get a defense verdict? Or is it just cheaper and simpler up front to pay off the client to begin with? And that's what happened. He got a fairly sizable settlement out of the deal, $4 million. But instead of putting it toward Mr. Johnson or giving it to Mr. Johnson, and releasing his lien and going about his business, he instead took that money, according to the U.S. Attorney, paid off his own debts, and then failed to pay off Mr. Johnson's debts, failed to take care of him. One of the things that Mr. Avenatti did shortly after he was involved with Stormy Daniels is he was sued. His firm had to take bankruptcy, and one of the things that happened in bankruptcy is he had to undergo an examination under oath, where he essentially admitted that he had converted all of these funds to his own personal use. Immediately after that hearing, or that motion, or that examination under oath, he went to Mr. Johnson and got him to sign a declaration that basically said he was the best lawyer that has ever walked upright, and he waived all liability against Mr. Avenatti. Basically gave him a clean bill of health and said, yes, I don't want anything more from Mr. Avenatti. Well, there's a problem with that. Here's what the U.S. Attorney said on direct examination in Avenatti's trial. Did you have another attorney look at this document for you? No, I did not. Well, ABA Model Rule 1.8H, which is not directly relevant here because California has different rules, basically requires that a lawyer shall not make an agreement prospectively limiting the lawyer's liability to a client for malpractice unless the client is independently represented in making that agreement. So what has to happen here is there has to be another lawyer involved negotiating on the part of the client. That didn't happen, so to a certain extent that agreement is more or less null and void. The other thing that the U.S. Attorney asked him was this: did Avenatti tell you that he had just been accused in a court proceeding that day of stealing your settlement funds? And of course the client said no. On direct exam, Johnson testified he had no idea that Avenatti had actually settled his case with Los Angeles County for a lump sum of $4 million years before without paying him. That is an absolute terrible thing to learn when you're a client. What happens after the direct examination, of course, is cross-examination. Now, there are certain rules that lawyers respect on cross-examination. There are several strategic rules with regard to cross-examination. One of them is first do no harm. If a witness hasn't hurt you on direct examination, there's no need to cross-examine them unless they just completely undo the other side's case. Another rule of cross-examination is you don't ask questions you don't know the answers to. And another is that you ask short questions, very focused, one fact each. For example, if it was a car accident case, you might say, you were driving your car. Yes, I was. You were driving on Fifth Street. Yes, I was. You came to the intersection with Elm. Yes. You saw the light? Yes. You saw my client's car? Yes. You hit my client's car? Yes. I mean, what else are they going to say, right? So, the thing that you have to do is you have to get these questions down before you go in. Before you go to cross-examination, you have to know exactly what you're going to get and exactly how you're going to get it. And if someone you expect to give you a hard time or maybe not tell the truth, you have to be able to teach them early on that there's a penalty for not telling the truth. You have to be able to, for example, pull out a document and show it to them and say, this document disagrees with that. This document doesn't say what you just said. And so those are the kinds of things that you do on cross-examination, because the whole purpose of cross-examination is to bring out the misrepresentations and the outright lies that the other witnesses tell. So with that in mind, we should look at what happened with regard to Avenatti's cross-examination of Mr. Johnson. I believe I had mentioned earlier that on direct examination, he had admitted that he had been in the jail and that he'd had this terrible outcome. But he was still in jail. Even after he was injured, he was still in jail. So one of the things that Avenatti did was get him out of jail. So the first thing that Avenatti does in cross-examination is this line of questioning. Do you recall asking us to do everything we could to get you out of jail? He said, well, I just don't remember. Well, at the time, did you want to get out of jail? Absolutely. Why is that? Because jail is hell. Okay, everybody knows jail is an unpleasant place. He's just gilding the lily. He's just saying, wow, look what a great guy I am. I got you out of jail. I got you out of jail, and here you are trying to put me in jail. Well, if he'd stolen $4 million from me, I'd probably be wanting to put him in jail too. Regarding the services that Avenatti provided through the law firm, he asked him this. And did you appreciate me in every bit of my time and energy? And the guy said yes. And certainly he would have appreciated the time that Avenatti spent with him because he thought he was going to get $4 million out of the deal. He didn't know that Avenatti was not going to pay him. So again, that kind of cross-examination, because it doesn't go to the elements of the crime, it doesn't go to what the kinds of things that Avenatti needs to prove to show that he's not guilty, does him absolutely no good. He's a lawyer. He should know that. But because he is crossed up with self-interest and he lacks objectivity, he goes for the cheap shots instead of those that would perhaps push him down the road toward a possible acquittal. So then Avenatti asked him about the fee agreement. He said, do you recall whether or not the fee agreement, if it required Avenatti and my firm to pay you for living expenses and medical care, and also where it said I would help you with your Social Security? And the client said, I don't think there's anything like that in here. I don't think there's anything like that in here. Okay, again, you ask the guy the questions that you know the answers to. So one of the things that is very important when you're dealing with evidentiary issues is you file things called motions in limine. And a motion in limine basically says to the court, look, we think the government's going to bring up my conviction in New York. I want to keep my conviction in New York completely out of this. It's not relevant to what's going on here. And indeed, it's not relevant. And the reason it's not relevant is because you're tried for the crime that you're accused of, not for crimes you've already been convicted of. But, and this is a big but, you can make it relevant by asking questions about it. And that is apparently what Mr. Avenatti did. You can't open doors that you previously closed. He filed a motion to keep out this New York conviction. He asked a question on cross-examination that called for an answer that implicated that conviction, and the judge allowed the prosecution to get into evidence that conviction because Avenatti had opened the door. So we started this with a question. Does a lawyer who defends himself have a fool for a client? You get to make that call in this case. So there you have it. Hope that's the story on the Avenatti trial. Hopefully you found this interesting or helpful. If you would, and you haven't already, please go over here and subscribe. Touch on that icon that says notifications and select the bell at the top so you can be notified all the times when we answer or when we post a video here that answers a question. And then, if you would, I would also appreciate if you give me the old thumbs up, tell the YouTube algorithm that you like this video. It lets YouTube know that the content here could be useful for other people. Thank you again for watching. I hope you have a terrific day, and I'll catch you out here next time.